Good afternoon. I'm Cam Carey. I'm the Ann and Andrew Tisch Distinguished Visiting Fellow here at the Brookings Institution, part of the Governance Studies program. Good afternoon and welcome to #the Privacy Debate. This is something that a project that we launched a few months ago. As some of you know, I see a former partner of mine here. I left the law firm where I was part-time a few months ago to focus on the work at Brookings here and to use my role and the Brookings platform to advance the privacy debate. Privacy legislation's unfinished business for me from my time at the Commerce Department, leading the Consumer Privacy Bill of Rights and trying to put that in the form of a bill. And I wanted to be able to engage in the debate. And I can tell you, a lot has changed since the time that I was working on that. Then most Republicans and some Democrats were asking, why do we need regulation? And saying, if it ain't broke, don't fix it. Now we're hearing a broad consensus from really both sides of the aisle. We need to regulate. We need to do something. Back then, as we were working within the Department of Commerce on drafting legislation, looking for partners on the Hill to partner on the legislation and preparing a bill. I couldn't find any. Now we have members, of all kinds, introducing bills, committees, conducting hearings, and lots of people putting down markers in this debate. This has become a mainstream issue. And there is an opportunity now to get something done, and we need to act before that opportunity fades away, before it becomes a wasting asset. And I will tell you that in these past months, I've been having a lot of conversations with stakeholders across the spectrum, with trade associations, with privacy and consumer groups, and other civil society, with individual companies. And I am struck by the opportunity that's there. Do not underestimate how many companies genuinely want to see some privacy rules in place. And it's not all about preemption. Sure, they want to see standards that will unify the privacy practices in the United States, but also across the world. And they want a reason for consumers to trust them. And I'm finding, too, that privacy advocates, consumer advocates, civil rights advocates understanding this opportunity and the opportunity to bring real protections to all Americans. So I see a political will among stakeholders who are engaged in this issue, and I think the question now is whether there is the political will in Congress. So today's program is going to focus on a key issue in this debate, because so much of this debate has been focused on social media and on big tech companies. But there's a lot more to privacy and data collection than that. These are really just a very, very large tip of an enormous iceberg. We are in the midst of what I've described as a data big bang, an expanding data universe that's driven not only by historically what we've had as expanding computing power, but now driven by network effects, the expansion of networks and devices everywhere, connected all the time. and connectivity and bandwidth that are expanding the amount of data exponentially. And it cuts across all sectors and all spheres of activity. So all this data moves through various ecosystems, and the crux of this debate is what are the boundaries that we put on what's collected and what's shared in that process. These ecosystems have tremendous ability to expand the frontiers of human knowledge and efficiency and innovation in our economic system. But obviously tremendous implications for all of our privacy as the aggregation of information becomes more and more granular. So that's what today's panels are going to explore. It seems like this past week, everywhere you look, something is going on. There's some news in terms of how data is shared that's in the spotlight. Last week, the UK's Information Commissioner Office issued a report that raised serious question whether the ad tech practice of real-time bidding that enables advertisers to bid instantaneously to serve an ad to an individual, whether that complies with the European Union's General Data Protection Regulation. The Washington Post had a deeply reported story on focused on the Chrome browser and how browsing and cookies enable collection and sharing of data. We saw the Senate Commerce Committee this week and the Banking Committee earlier this month exploring how data is collected and shared. During one of our panel calls to prepare for today, I said listening to our panelists, we really could have a whole day's program on this issue. And in fact, the Federal Trade Commission is doing exactly that today at its privacy conference. And we're fortunate to have Justin Brookman, one of the experts there as part of our panels today. So I'm not going to introduce all of the panels. I will leave that to our excellent moderators. So for the first panel, looking broadly at how data is collected, how it's used, how it's shared, we have Molly Roberts, an editorial writer for the Washington Post. She's on the editorial side, not the news side, but we'll still give her credit for that scene-setting story in the Post last week. And for our second panel, we have Stacey Gray, who is Senior Policy Counsel at the Future of Privacy Forum think tank and leads the ad tech working group of FPF, really tries to keep its members and associates abreast of what's going on in ad tech. It's a continuing moving process. And we have a terrific group of panelists who bring broad perspective both on the technology, on the systems, as well as on the policy issues. I want to acknowledge and I'm grateful to Workday, who's represented here by Jim Shaughnessy, for its support of Brookings independent scholarship. So please silence your cell phone, but feel free to use it with the hashtag. Well, it has data collection. It should say hashtag the privacy debate, but you can use either one. So the challenge that I want to put to panelists today and ultimately to legislators is this. In a democratic society, we believe in the value of information, in the flow of information, in the advancement of human knowledge. And as individuals, we are motivated to share as part of how we interact with people, as part of the activities, the world around us, whether it's connecting with community, to buy products, to protect the security of our devices or our information, to get free services, or to express views on the issues of the day. But we want to be assured that the information we share for these purposes is going to be used in ways that are consistent with our expectations, our interests. And too often, we don't have good enough reason for this assurance. And that's especially a challenge in the areas of the subject of the second panel. Data is like water, it flows, and it leaks. And we see that in ad tech, some of those real-time bidding systems may be designed to serve ads without using names or other identifiers, without disclosing that identifying information, but that there's the ability to retain information and to correlate it with other information to build profiles. The ICO in England found that a single visit to a site can generate hundreds of contacts and circulate information to hundreds of organizations. And as new developments, cookie controls, ad blockers, ad IDs come into play, somebody, to protect privacy, somebody manages to design around them. So we are, in effect, in an arms race in ad tech. And the only way I think we are going to deal with that is with a set of ground rules that create a set of rules that everybody has to play by, and that punishes those who break the rules. So the crux of that debate is rules on collection, on use, on retention and sharing of data. That's what's going to change the system that we have today for most of the data that's collected. And it's certainly not to double down on a system the existing system by treating data as property and simply substituting negotiation fatigue for click fatigue as we have today, and as John Morris and I have written in a Tech Tank blog post out today. So legislation won't be able to address all of the contingencies, but it can address developments with broad enough enforcement powers and tools like rulemaking and enforceable codes of conduct. So I raised the question at the outset, whether there's the political will on Capitol Hill, and I would say, we have been seeing an unusual effort to legislate in the classic sense, to learn the issues, to build coalitions, to work on a bipartisan basis, to reach out to stakeholders. But we need to seize this moment before the default to polarization and partisanship takes hold, before people become hardened in their positions, before more states step in and preemption becomes more intractable, before people decide that privacy legislation is just too hard. So Shakespeare wrote that there is a tide in the affairs of men, and I would add women, which, taken at the flood, leads on to fortune. Omitted all the voyage of their life is bound in shallows and miseries. On such a full sea are we now afloat, and we must take the current when it serves or lose our ventures. So I think Shakespeare must have been thinking about baseline privacy legislation when he wrote that. We are on a full sea today, and we must need to take the current when it serves or lose our ventures. So thank you very much. And ladies and gentlemen, I give you our first panel and Molly Roberts.
I'm an editorial writer at the Washington Post covering technology and society. So that involves a lot of things, but it has also involved, especially this year, data privacy. So I'm really excited to be here and talk to people who have been doing a lot of work and a lot of thinking in that area. Also, like Cam said, when we talk about data privacy, we usually think about social media, targeted advertising, marketing, and you guys will get a chance from the second panel to hear a ton about all of that. We also are mostly thinking about those things when we talk about what the writer Shoshana Zuboff calls surveillance capitalism. She defines that as a new economic order that claims human experience as free raw material for hidden commercial practices of extraction, prediction, and sales. Big data is obviously much bigger than social media, and the ways that information is shared for public and private interests are vast, they're varied. They go from the Internet of Things and smart cities to research, to health monitoring, and beyond. These information ecosystems, which is what we're calling them here, obviously come with benefits and they come with costs, and any privacy legislation that we hope is forthcoming will necessarily mean some trade-offs between the two, which is what we're here to talk about today. So we have here to talk about that Trevor Hughes, who is the president and CEO of the International Association of Privacy Professionals. We have Amy Stepanovich, who is the U.S. Policy Manager and Global Policy Counsel at Access Now, an international nonprofit that advocates for a free and open internet. We have Jim Shaughnessy, who's General Counsel at Workday, which offers human resources and management software to workplaces, including mine. And we have Lauren Smith, who is Senior Counsel at the Future of Privacy Forum, where she focuses on big data and the Internet of Things, especially as it relates to connected cars. So we thought, since it's a broad topic, it would be useful to start pretty broad and get an overview from everyone on our panel, starting with Trevor, who really has that whole expanding universe of data under his umbrella, and Amy as well on that broader level, and then maybe more specifically in the context of what they're working on, Jim and Lauren. So if you want to take it away, Trevor.
Great. Thanks, Molly, and thanks to Cam and Brookings. This is a wonderful gathering and an important conversation. My name is Trevor Hughes, and I lead the IAPP, the International Association of Privacy Professionals. We are a not-for-profit organization based in Portsmouth, New Hampshire, and we are the professional association for people who work in this emerging field of data protection and privacy around the world. We have 51,000 members in 120 countries, and currently we are adding over 1,000 members a month. So something is happening. Something is happening out there in the world. This issue of data protection is driving behavior not only in the marketplace, but also in the public sector. We see both governmental and private sector privacy professionals flocking to the IAPP. Our conferences are full, our certifications are growing and expanding around the world. I thought today that I would offer a bit of perspective of the growth of the profession and then come back to how I think that may actually speak to some of the policy issues that we're facing. Before I do that, let me just mention that the IAPP is policy neutral. We're not an advocacy organization. We intentionally like being a big tent. We like to say that we don't take sides in the fight, but we really like the fight. And so all of the combatants, we welcome them to our big tent. So anything that sounds like an opinion is probably mine and shouldn't be attributed to the IAPP. The privacy profession is relatively new. The IAPP was formed in 2000. Some of our earliest members are actually here in the room with us today. And it has grown significantly since 2000. But in the last 2 years, we've doubled in size. I mentioned we have 51,000 members. Just 2 years ago, we had 25,000 members. So something really significant happened in the last 2 years. And I think it's fair to say that the acronym behind that happening was GDPR. The General Data Protection Regulation in Europe drove significant activity for the IAPP. We have 26,000 members here in the US, 16,000 members in Europe. And so we have more members in the US than we do in Europe, even though it is the GDPR that has really driven much of the activity. In fact, our European certification is our largest selling certification here in the United States. And so one of the things that I think is really notable is that these policy developments like GDPR, and actually we can look back to 2003 and SB 1386 in California, the first data breach notification law, that really drove a pop in IAPP membership. These policy developments have consequences in the private sector. Organizations understand and assess the compliance risk, and they respond to it. Interestingly, because of the extraterritorial nature of the GDPR, the US and the rest of the world is actually responding to this European policy initiative in a very significant way. And I don't want to overstate this, but I think it is fair to say that in terms of influence around organizational behavior with regards to data around the world today, the GDPR is the guiding principle. In fact, our European certification is our largest certification in every region of the world: Asia, Australia, New Zealand, Latin America, here in the US, and certainly in Europe. I also want to mention that the growth of the profession, the growth of the operationalization of privacy, has also occurred absent policy initiatives. So prior to GDPR, here in the United States, we had many thousands of members, and that was in the absence of a broad-based policy initiative, a broad-based privacy law here in the United States. I think that's because the complexity and risk associated with data in society has been on an ascendant path. And that complexity and risk, when organizations look at it, they respond to it by using the best tools that they possibly can. And in the absence of clear guidance from public policy, they revert back to smart people in the right places making good decisions for their organization. They revert back to professional judgment, business practice, and risk management inside their organizations. And so even without public policy initiatives, we have seen the rise of the profession of privacy, which I actually think is one of the interesting and less documented realities of the new digital economy, that the profession has emerged. The risk management tools, the business practices of managing data inside organizations have really emerged in the absence sometimes of public policy initiatives. Deirdre Mulligan and Kim Bamberger wrote about this really well and thoughtfully, I think, in Privacy on the Ground, a book that I recommend to all of you. I think we are in a special moment, though, and Cam captured that poetically with Shakespeare. I think we are moving out of the Alan Weston era of thinking about control as the primary mechanism in which we manage data, and into a more complex and fragmented set of tools that includes public policy, but public policy that drives particular behaviors. I think it's notable in GDPR that there are tools within GDPR that move beyond control and towards accountability and also towards user empowerment, towards data subject empowerment. Requirements around accountability so that you know what data you have, you know how you're using it, and you know you can report out on that. But also that a data subject can come to you and say, show me my data. They can also say, delete my data, or give me my data. Those are really powerful tools, and they are different from our prior era of public policy responses, which largely wrapped around notice and choice. And I think that gives us an indication that we are headed towards more of an accountability and stewardship model with regards to data, with some, I think, legacy notice and choice controls still in our public policy. With that, I'll pass things on, but I think it is an exciting moment for us. And I just want to note for the room that one of the things to watch is not so much, yes, watch the public policy debate, and absolutely I'm glued to the news every day because there's something happening in our field. But look at what the operational response is inside organizations, public and private, around the world, because that's where you're actually going to see how organizations are dealing with the risk and complexity that they are facing. And it's been a pretty remarkable response. I have 51,000 members who are part of that response, and I think it's a big part of the story.
Great. And Amy?
Sure. So we're going to hear, I think today, and we hear in life almost, a lot about the benefits of technology and the collection of data and the way that it drives forward society in really positive ways, provides positive benefits. And because I often get told that I am a pessimist in this field, I do want to start off by recognizing I think tech is really cool. I have read and watched sci-fi since I was really young, and my parents introduced me to Star Trek and Star Wars, and I thought that is really neat. And the fact that the technology that I was seeing then is now far surpassed by the object that I carry in my pocket and this thing I have on my lap, that's fascinating. And so we're in a moment right now. And somebody said to me recently, we're going to be, really, the people in this room, one of the last generations that remembers what it's like before that was the case, and who has some idea of the pre-technology world in order to judge how this is impacting our lives. And so where I want to go is, yes, it's really cool, and I want that tech future. I want to build it. I want to see where we can go. But it comes with so many risks attached to it. And to really kind of tease out those risks, because if we don't plan for them, if we don't protect the most marginalized people in our communities, then we're going to stray away from the future that could be into one of those dystopias that we see in movies and have for the last few decades. So there are 4 points I want to make to start off, and then kind of get into the discussion, and I hope to move pretty fast. One is that there are a lot of layers to data collection. And so we like to think about data as the posts that we put on social media or the information that we turn over to certain companies when we sign up, our name, our address, our phone number. And that's all really important. But it's really only the surface layer of this ecosystem that we're talking about. And underneath that is the information that's picked up just by virtue of our existence. When we walk around in the world, when we carry our phones, when our location is tracked, information that is picked up by inference. When we sign into certain services, there are implications about when you're using those services. When do you eat meals in the evenings? And when are you ordering delivery? That can lead to certain types of implications that get put into profiles about you and cause for certain decisions and determinations to be made. And then when we get into smart cities, connected cars, connected workplaces, to talk about two of the things that we're going to go into more detail, that collection gets a lot bigger. And so it could be our conversations walking up and down the street, picked up by a smart light post, which was something that I was researching in my career 8 years ago. You think about these things as new technologies, but they've been around for a while and they're being deployed. It could be what is going on in our bedroom or what our children are doing through connected toys that are now collecting all sorts of information. This world is very large, and we have to be thinking not only about that surface layer, but all the way down the stack. The second thing is choice. So when you get away from that top layer, and I would argue that we really don't have much of a choice about that top layer either if we want to participate in society. But as we go further down, choice seems to look like less of a solution. when you're interacting through voice technologies, when you have these different interfaces, you can't necessarily opt out to the extent that you could choose not to use Facebook, for example, something that a lot of people use as an example for me today. And so if we focus around choice, and I think that's a theme that we've already heard today through Cam's opening remarks, through what Trevor said, we're losing part of the conversation. And so getting way past that in order to address all of that other collection. And the threats that are both seen and unseen. There are real worries that I think people have about the data that is collected about them and how that can be used. And there's the overt threats of for some people, I'm getting served an advertisement that I don't want to see. I don't know if I necessarily see that as a threat, but some people do, and I take that to be legitimate. All the way down to I'm having my information turned over to police and it's being used to track and monitor my movements, which I think we see as a much more legitimate reason and thing to worry about. And that's just my basic data collection. When you move deeper and we talk about manipulation of people's activities and habits and the way we think, that's kind of where the future of technology is going. It's getting into a place where we're getting subtly nudged in certain directions by companies because of the data they're collecting about us and the profiles that are being built. And those threats are really seen by certain communities. And so I'll end by talking about some of the communities that I think both really benefit from technologies, but are going to have more threats placed on them because of that. And I'll call out two. One is going to be the LGBTQ plus communities. It is unquestionable that these communities have benefited from being able to connect through social media, from being able to share their stories, from being able to have support networks in places where they may not have ever had before. And that's been a tangible benefit to some of those communities through technology. It is also unquestionable that they have faced arrests, sometimes worse than arrests, torture, imprisonment, et cetera, because of data that has been collected through these platforms. Some people have been ostracized. There are people who have been outed. There was the situation at the Olympics not too long ago where reporters were trying to identify LGBTQ members in the Olympic population through their use of applications like Grindr, and they were getting on there to try to figure out who those people were. And so seeing the benefits and then the threats that are faced, we want to emphasize the benefits while really preparing and putting in the protections we need to make sure those threats are limited however possible. The second one is the accessibility community, and I think this is where we see it even more pronounced. There are people who are blind, who can't hear, who can't walk, who can't really get around. Technology has helped them interact with society in a way they probably never could have before, to describe what is being put in front of them, to go out and move around and be more mobile than they could have previously. And so it's provided a lot of benefits. But when a piece of tech can see every single thing that you're interacting with throughout the day and collect information about you, or hear every conversation that you have, and they're purposefully collected, the purpose for the technology is to collect that information to be able to provide the benefit and to create those profiles and make sure that they're serving those populations. Those come at great risk for long-term marginalization and further detriment to the communities. And so what we're looking for is to measure the potential threats for those communities, look at the solutions in the form of potentially US federal legislation, state legislation, laws in other places around the world, and make sure that we're accounting for the threats that those communities could face and that we're going to be protecting them in the long run. So that's my pessimistic take before we get into the other cool things that's going on.
Sure, yeah, a little more optimism in the cloud computing context.
That puts a lot of pressure on to be that cheerful about the different view of the future. But thanks for that opportunity. And thanks to Brookings for putting this event on, and particularly to Cam for organizing it and bringing us all together. And I'd also like to commend Cam and John Morris. I read the blog that was posted yesterday, and this is a subject about which I spent a lot of time thinking, and thought my thinking was pretty advanced. And I read that blog and thought, well, there are a number of things that I was probably not thinking about the right way, and so it will change a lot of what we do. So I really commend it to everyone who's here to find it. Manage it's pretty easy to find online now, and read it because it's really quite insightful. So I'm here to talk about this from the privacy debate from a different perspective that most people think about when they think about privacy, and that is the perspective of enterprise cloud companies, and of which we're one. So the first is a rhetorical question, and you can raise your hand or not, but I assume that many people here took Uber or Lyft to get over here today. Me too. If you got a text message from whichever service you use that seemed to be from the driver, we're actually interacting with an enterprise cloud company, and it's Twilio Systems, which provides the backbone for all of that. And I don't know if anyone, on a day like today, people are probably thinking about getting out of Washington for summer. It's kind of hot, get someplace cooler. If you've made your arrangements through Airbnb, probably a few people have done that as well, and you've interacted with customer service, you're probably interacting with another enterprise cloud company, that's Zendesk, who provides that level of service. We provide a different level, different type of enterprise cloud service. We provide human capital management, financial management, and analytics and planning solutions to large enterprises and including government organizations. We're a young company, only 15 years old, but we've been blessed with a lot of success and great growth, and enough that we now count 50% of the Fortune 50 and 40% of the Fortune 500 as our customers, including the wonderful Washington Post, and hopefully organizations you all work for. Or if not, we can make an arrangement for the future. But as part of that, we've been entrusted with the records of about 39 million employees of those companies, and many more non-employees, including dependents of the employees and as well as former employees. And it's interesting how that works, because every employer for which I've worked since 1988, which is longer than many of the people in this room were born, but now uses Workday. And so I may have my records in Workday in multiple different locations. But Workday wouldn't know that, as it turns out. What we do is we, like other enterprise cloud companies, we have a different relationship to data than our social media counterparts. We don't monetize data. We get paid by subscriptions from our customers, and they pay us well, thankfully. And we help customers make better use of their data, which they entrust us through highly functional software, including for us applications and features that are enriched by machine learning algorithms and other technologies. But it's all about helping customers make better use of the data. So for us, it's helping customers recruit the right people. It's helping them hire and bring them on board. It's helping them with their development and their training. It's helping them pay them, hopefully the right amount and on time, because that's generally appreciated. And then help also delivering benefits. So another way of thinking about this is we don't really make decisions about the data. Those are made by our customers, who control the data, and we just do what we're told as we process the data. And our business depends, like the other enterprise cloud companies, on a high degree of trust with our customers, and they have to have similar levels of trust with their customers, or else the system doesn't work. And turns out that we all operate in information sharing ecosystems that are already pretty highly regulated. So we've talked a bit about GDPR. GDPR is a regulation that impacts the information sharing ecosystems in which we operate. But it's also a function of employment law, payroll law, tax law, benefits law, HIPAA, and a variety of other regulations that apply to these specific contexts. But despite this existing regulatory framework, which actually provides more protection than people generally recognize. We are one of the companies to which Cam referred to are supportive of strong federal privacy legislation. We believe that that it's important, one, to establish trust, and it's important to ensure interoperability among regimes operating around the world. And there is, the GDPR is the leading regime now, and it does influence behavior all over the world. And also to achieve consistency in treatment in the United States. And I'm fortunate to be a resident of California, where I will receive protection under a landmark state statute that was passed in the last year and goes into effect next year. But I would, as an individual, I much prefer the protection of a strong piece of federal legislation that would ensure that I'm protected wherever I happen to be and drop data, wherever it happens to show up in the United States, and would provide the interoperability that we've talked about in the past. We think that the federal legislation, like GDPR, should be based on the OECD Fair Information Principles. We believe in strong enforcement by the FTC and also by state attorney generals as appropriate, and we'd love to see them have the power and the resources necessary to enforce. And also believe that it's really important that the legislation be nuanced to recognize the operation of different information sharing ecosystems, different characteristics, and particularly how those that are those obligations would likely differ for controllers and processes, just like in GDPR.
Great, and finally, Lauren.
Great, I'll try to bring some optimism as well. So you may be surprised to see a focus during a panel talking about privacy more broadly, to have a conversation focused on connected cars and mobility technologies. But this is actually a really fascinating space from the perspective of privacy right now, because it's a space where you can see very clearly some of the benefits of advanced technologies and sensors to literally save lives. But you also see a space that is at the very early stages of the creation of a data ecosystem. And there's a lot of promise there, but there is, I think this sector can learn a lot from lessons that have been learned in other areas, like we'll hear about ad tech. And there's a lot of possibility if privacy is taken sort of seriously from the outcome. And there's a lot of promise from the safety perspective. So just to level set a little bit, data collection in cars is not entirely new. There have been computerized systems in vehicles since the 60s, and there are a couple that are in nearly every car today. One is the event data recorder, which is the sort of black box of your car that records information related to a crash or a near crash event. And the other is the onboard diagnostic system, which is what sets off your check engine light and allows you to go into a repair shop and they can look up with a code to understand what's going on a given car. But despite those being in cars for a long time, there are some significant new developments in this space. When I go to transportation conferences, the sort of takeaway message is that the transportation space is going to change more in the next 5 years than it has in the last 50. So there's a very rapidly changing sort of change or die, adapt or die perspective in this market right now. And a lot of that transition is including looking to data to see, are there new technologies that we can incorporate, such as, say, autonomous vehicles, as well as are there market opportunities to use and monetize this data in a way that will be essential to being a part of this ecosystem going forward. So, as these technologies are integrated, cars become more and more like computers than these kind of mechanical chassis that we're used to sort of safeguard our autonomy and freedom. They've become essentially another item in the Internet of Things, but it's actually not just one item. When you get into a vehicle, there may be a number of IoT technologies inside. So questions that are being raised around biometrics, questions around microphones, always-on technologies, ISPs, video screens, web browsing, all of that can actually happen within a single vehicle. There's significant growth in this space, so some estimate that 286 million connected cars will be added to the market in the next 5 years. So I think it's going to be hard in 5 years to actually find a car that doesn't have some sort of connected technology. So the good news is that these sensors that are powered by this data have the ability to transform safety and convenience on the roads. Right now, the statistics for car crashes in the US are very grim. We've sort of become desensitized to them, but 37,000 people die in car crashes every year here, and human error is a factor in 94% of those crashes. So a lot of the new technologies in this space are being developed to help mitigate some of that human error. So one way of looking at it is your car is learning more about you, but what it learns may save your life. I'll give you a couple examples of some of these technologies. There are external sensors that are analyzing the environment and reacting within the car, as well as internal notification and convenience features. One example is automatic emergency braking, which uses camera or radar-based sensors on the front of the car to brake automatically if it detects that an accident is about to happen and the driver hasn't braked in time. Eye tracking technologies can track whether a driver is paying attention to the road and send notifications if they're falling asleep. There's also advanced versions of that now that try to do health monitoring to tell if someone is having a health incident and can pull the vehicle over. Vehicle-to-vehicle communication enables the sending of messages between nearby vehicles that can send location, braking status, and heading. So if a car in the front needs to brake suddenly, it can communicate that message several cars back to help avoid a pileup. This technology was estimated by the Department of Transportation to potentially address up to 80% of multi-vehicle crashes. And there was actually a lot of work done to create a federal mandate that would require vehicle-to-vehicle communication in all new cars, and it would be mandatory, no opt-out available. That is not currently going forward, but it was proposed during the Obama administration, and there's definitely going to be versions of this technology incorporated going forward. The debates are around the band of spectrum and not about the use of the technology. So at the same time, the volume of data has significantly increased, both the data that is generated and collected as well as shared off the vehicle. So the Intel CEO has said that one autonomous vehicle will use up to 4,000 gigabytes of data per day. Others have said AVs being tested could generate up to 1 gigabyte per second. So we're talking large quantities of data. For AVs in particular, this enables the machine learning process to sort of analyze and learn from prior incidents and hopefully prevent future accidents. But even on your way up to autonomous with more and more connected cars, there are more and more devices. Some of these come built into the car, some can be added on. You may be getting advertisements from your insurer that you can plug in a device to your OBD port and get a safe driving discount because they'll analyze your driving behavior and supposedly determine if you're a safe driver or not. So that's something where you may own a Ford car, but you may buy a Verizon plug-in. So there's a couple different entities there. There's also syncing between phones and cars, which is not always done in the most notice and consent-friendly way. Another big change is the air gap that used to exist, where you needed to go to a repair shop and have them plug into your OBD2 port to read the codes. Now that air gap is gone, and increasingly information is being sent off of the car. A range of technologies are leveraging that connectivity for services, and that information can be transmitted in a variety of ways and is collected by a growing variety of parties. So this is sort of a new space, and the types of data involved range from sensitive, privacy-relevant types of information to less so. So when you're dealing with, say, infotainment and personal communication data, that could include your contacts list. That could include phone conversations that you're having when you're in a vehicle. Then there's sort of less sensitive data, but they may be linked to your individual car, like vehicle health and operational information. Just like any other technology, there are conveniences that users may be interested in. There are partnerships like Warner Brothers and Intel partnering to be able to show video content in autonomous vehicles, which you can imagine consumers enjoying being entertained while they're in a car without needing to steer or drive. There will probably be commercial breaks. There's increasingly, we're seeing GM has a marketplace option where you can get advertisements for discounts on nearby stores. So there's a lot of unresolved questions in this space. Who gets the data, who manages the consumer relationship, and what information is personal. Again, we're in early stages, and the data flows are not exactly clear. So the data may go directly to your manufacturer, that you know who that manufacturer is because you bought a car that has the symbol on the front. But in the automotive space, there may be suppliers involved. You may be in a ride-sharing vehicle, so the ride-sharing platform may have information. the services that you sign up for, subscription-based services in the car, that information may go directly to the company that you've signed up for. It may not actually go through the manufacturer. So that's going to wind up being a big consideration when it comes with sort of complying with some of these new laws and thinking about how to regulate this space, is that the data flows do not necessarily go through the entity that the consumer has the direct relationship with. I think that can raise a lot of questions when it gets down to notice, access, consent. There's growing methods of monetization. As I mentioned, there's a small number of connected car data marketplaces that are just beginning to navigate this space. This is seen as a potential very large market. McKinsey estimated that money from car data monetization could be worth as much as $750 billion by 2030. So there are a lot of opportunities there, and we'll sort of see different folks experimenting with how to make the most of that. Automakers proactively saw this issue coming, and they created a set of privacy principles in 2014 that nearly all of them signed on to, which is a great first step, modeled mostly on the FIPS. There are a couple major commitments around transparency, so having privacy policies, around affirmative consent for sensitive data, things like biometric, behavioral, and location data, as well as limited sharing with government and law enforcement. So compliance with those, I think, gets folks along the path towards being compliant with other privacy laws. That said, this sector is, again, very new and growing. And there are a lot of dynamics around access to this information, and folks are in different spaces, from automakers to ride sharing to repair shops to rental cars, are just starting to navigate what data they have access to, who owns and controls that data. And I think we're seeing that play out in some of the conversations around privacy regulation, where folks are seeking carve-outs for safety data, but there are also underlying questions around who in this space has access to which data, and those will be important going forward.
Well, thank you guys all so much. We have a lot more to work with than we do time, but we will do our best, and also do our best to leave time for some audience questions. I think the best place to start might be the question of notice and choice, or notice and consent. It is definitely a thread that I heard running through this. So I wonder if we can begin, Amy, with you saying a little bit about, there's this feeling that notice and choice is not enough. If it's not enough, what makes sense to go on top of that? We've heard about obligations on the companies holding the data that are kind of broader. We've heard terms like duty of care and duty of loyalty thrown out there. We've also heard about more explicit use limitations. I'm curious, from your point of view, what sorts of things are necessary? What would work well?
Sure, and I think Trevor said a really important word. Actually, he said many important words. A couple of them, he started by saying we have to move away from a framework around control and move toward one of empowerment and accountability. And I think empowerment and accountability is right, but I would almost say we never really had a framework about control, because it wasn't really, without the empowerment and the accountability, that control element was never really there. And so I guess I would answer your question with three things amongst many other items that we would like to see. One is those use limitations. We think that data should only be collected or used if it falls into one of a certain enumerated set of categories. And this is straight out of the GDPR. Consent was one of those, but you could argue, and many do, that consent in the GDPR is not even the best bases for collecting information. The GDPR also has legitimate interest of the business. Mm-hmm. And our take is that probably is a bit too broad, actually, from a human rights perspective, and it needs to be narrowed down in a way that is more meaningful, because legitimate interest of a business can be interpreted very, very broadly. So that's the first set of things. The second is actual actionable user rights. And I think this is at this point, 2 years ago, I couldn't have said this, but at this point, a pretty non-controversial aspect of what we're looking for in federal privacy law. You should have the ability to access the data that somebody has, that an entity has about you, to port that data somewhere else, to delete it if it's no longer going to be used by you, if you want to leave a service. Now, those rights shouldn't necessarily all apply to the same categories of data. And that's going to be really important when you talk about all the different types of data going in. if I go to a company and ask them to exercise my right of access, I want to know everything they know about me. I want to know what they have, the inferences they're making, the whole shebang. Now, I don't necessarily think I should be able to erase all of that data. There are a lot of genuine reasons for legal purposes. If it's a photo that I happen to be in, but somebody else took it and is responsible for it, that maybe shouldn't be something I have the power to cause them to erase. Same with portability. Not everything necessarily should be ported over. There are other privacy concerns that actually could be implicated in that. So we're going to have to determine what rights apply to what types of information, and that needs to be pretty granular. And then the third thing is this amorphous category of creative stuff that we've kind of been trying to think out about what should be in a federal privacy law to protect people. And one thing in that amorphous bucket of creative stuff is we've looked at federal benefits, either in the form of grants or tax breaks or incentives for contracts, to companies that explore business models that aren't based on data. And so if we can get away from that type of business model, it's not going to be necessary, we don't want to compel it, but to provide incentives to explore and to like gin up those creativity juices for business entities to get away from driving their business models based on data and look at other ways and other things that can take place. And so just a few things that we would throw out there.
And Trevor, I know that your organization doesn't take policy positions, but I'm curious about your take on the notice and choice question too, and maybe how some of your companies are thinking about, particularly in the context of GDPR, fulfilling their obligations on top of it.
Sure. So first, the IAPP has members across both the public and private sector. So it's not just companies. I think our members are struggling with notice and choice as a non-scalable method to respond to many of the challenges that they see in the marketplace today. And when I think about notice and choice, just from my own perspective, having been in the field for a fair bit of time, we've been critiquing notice and choice for a long, long time. Fred Kate, almost 20 years ago, wrote about the failure of the fair information practices. And more recently, Woody Hartzog has offered a really strong critique of consent as a mechanism. I think it is fair to say that these analog public policy tools are not working well in our current digital economy. They really are not working well. Here's a great example that we haven't talked about yet on the panel that I think demonstrates the tension of choice in a broad, technologically driven digital economy, and that is around genetic privacy. If I take a genetic test, I learn genetic information about myself, but at the exact same time, I am creating, disclosing, learning genetic information about many of my family members. And we are actually seeing a whole new realm of genetic surprise emerge, where things like artificial insemination, unknown parentage, and many other things are emerging from these multiple genetic tests. Now, there is no industry that layers in more consent than the genetic testing industry. I did an Ancestry.com genetic test because I'm a genealogy buff and love researching my family history. And I was a student of the consent process that I went through. And trust me, it was robust. But my parents, my brothers, my aunts and uncles, my cousins, none of them had any involvement in that process. And yet their data was implicated in that test. Consent doesn't work in that environment. And I think that's just one example that we could take out to the broader digital economy and just show that the complex data ecosystem which we currently operate within really doesn't allow for notice and choice to be complete solutions. I don't want to give up on them totally. I think there are moments, and I liked Amy's suggestion of layers of data collection and use. And perhaps at top layers, there are places where choice, where consent is a mechanism that makes sense. But broadly, I think there is a recognition that they are strained at least, if not failing.
And Jim, from your point of view at Workday, when it comes to that controller-processor distinction that you talked about, how does something like notice and choice operate in that context? And then how would a proposal, you talked a lot about trust, like a duty of care, like the idea of third-party obligations then being extended to parties further down the line, work for you?
So fortunately, notice and choice is not a feature of our relationship with our customers and data subjects. And by and large, given what our applications do, it isn't a big part of what they do. We don't have an ad tech application. And so while we try hard to ensure that not only can our customers comply with all laws that are applicable to them when they're using our software, but they have multiple degrees of freedom in choosing how to comply, that the notice and choice is a big part of that. So I can opine on that, unburdened by any sort of practical impact or knowledge. But it seems like, I would agree with others, it seems not to be working with the mass collection of data. And I think that a sort of a corollary to what Cam and John talked about in the blog a little bit is the concept of ownership isn't very valuable, but understanding who has interests in particular items of data, including items of data that they may not be able to claim ownership of, but may have still have privacy interests would be really valuable. The concepts of duty of loyalty and duty of care are interesting. In other areas of the law, they've taken a long time to evolve and a long time to decide exactly what they mean in particular contexts. And so expecting them to provide a lot of guidance in the short term, if we were to apply those to a particular controller, now you have a duty of loyalty or duty of care, that it wouldn't make things a lot better in any foreseeable time period. It might make things better for our great-grandchildren or grandchildren maybe, but not during our lifetimes.
I want to move on a little because I know, Lauren, you talked a bit about where notice and choice can fall short in cars, but I'm curious also about the question of any exemptions, and I know that in the car industry there's been a little bit of advocating for exemptions for connected cars. I want to hear from all of you ultimately on that subject. What is the best way to look at? Maybe there are some companies that are dealing with certain types of data or dealing with data in certain types of ways such that they should be treated differently. So one way to approach it would be these granular exemptions. Another way is something like a controller-processor distinction. Another way would be, if you don't monetize data, maybe we treat you differently. So to start with you, Lauren, just in the car context and exemptions, I'm curious how you think that should operate.
How it should operate, okay. I was going to tell you how it's currently operating.
Well, that works. We could start with that, and then we could hear whether you agree with it, how it's operating now, or want to change things.
No problem. So yeah, actually in the past month or so, there's been some movement around efforts to treat car data a little differently under some of the proposed privacy laws. So there's a couple in the works right now. I'll start with the broadest one, which is in the Nevada privacy law, which is now law, not in process. So that law actually includes a very broad exemption for automakers, repairers, and servicers, which pretty much relates to all car data. So this relates to any operator who collects, generates, records, or stores covered information retrieved from a car in connection with the technology or provided by a consumer in connection with a subscription or registration. The argument that was made for this exemption, as well as the other, is around primarily around ability to notify owners about recalls and safety or warranty related defects. And that's sort of been the argument that has been used in each of these spaces. I think the Nevada one is quite broad, and so it may be a little short-sighted in terms of how this ecosystem is evolving to look more like these other data ecosystems. California has, there's an amendment to CCPA that has passed out of assembly and into committee related to car data, but this one is much more narrow. So it allows car dealers to retain and share vehicle information, which is very limited. It's VIN, make, model year, mileage, and ownership information with the car's manufacturer, specifically for the purpose of complying with warranty, repair, or recall. So that one seems poised to go forward. But there's some other efforts elsewhere as well around these questions have converged with kind of the right to repair copyright issues that come up in the auto repair space sometimes. So Massachusetts, there's an effort, I think advanced by the car repair folks to ensure that they'll have access to future platforms and also trying to standardize telematics platforms. So we'll see where that goes. I think there's certainly, in some instances, a case to be made to treat vehicle safety data differently. Particularly, as I mentioned, DOT was considering mandating vehicle-to-vehicle communication, and the safety case is just very strong there. But I do think it's important to recognize that there are reasons why we are calling for a federal privacy law that would apply across sectors and ensure basic protections for consumers. And it's important to consider the space in that context.
Amy, your point of view on the topic of exemptions, I don't know if you have a broad level opinion on it.
I think there might be a place for it. I hesitate to endorse any sector-wide approach. And I think that we see some of that in the CCPA, and there are a lot of interest involved in getting some of those exemptions put into place. Some of what we see actually in the GDPR when it comes to exemptions, when it's like certain categories of data or certain levels of processing, that might be a better approach actually to look at and something that we'd be a little more supportive on. One of the things and one of the related topics here is this distinction between sensitive and non-sensitive data. And if there are going to be different standards that apply, if something is quote unquote sensitive, and that is in the GDPR. And we have in the US conversations actually tried to get away from that distinction outright, because when you start collecting and collating and combining databases, saying something is non-sensitive is really nonsensical, because you're putting it with a lot of other types of data and being able to make a lot of sensitive inferences.
And Jim and Trevor, I want to give you guys a chance to speak on this topic too before we move to audience questions, if you'd like to.
Yeah. So one thing I would say is that the controller-processor distinction is not really an exemption, at least in our view. It reflects the different roles that the two types of people have in processing in data. And as a processor, as I mentioned, like, we don't know the names of our customers' employees. We don't know how much they get paid. We don't know what hours they work. We don't know what locations they work, unless for some reason we're authorized to go in a support case because something's not working. And that's probably better, right? That we not know that. And so if we were, if we had the obligations of a controller, that a subject could come to us and say, "Well, show me the data," then we would have to be able to do that, which is probably not consistent with what we're trying to accomplish.
Terrific. Then hand it over to the audience, and we'll try to get in as many questions as we have. I think we have about 12 or so minutes to do that. Sure. Do we have mics coming around? Great. So yes, we'll start in the front row.
Thanks very much. Stephen Balcom with the Family Online Safety Institute. Amy, you mentioned two populations right up front, the LGBTQ plus and the disability groups. Where do you think children and young people fall in this debate? And particularly, how well or otherwise is COPPA, the Child Online Privacy Protection Act, holding up after all these years, would you say?
So I want to preface with this is not my area of expertise, but it's one of the populations that we think are definitely at greater risk of having their data manipulated and monetized, especially for longer periods of time. And in certain circumstances, it's something that we've looked for greater protection. In that population, we would put it within, Access Now focuses on quote unquote users at risk. And people often ask me what that means, and there's no definition. It changes, I mean, we work all over the world, it changes in different countries, it changes at different times in different regions. And for the US, I would say children are definitely at risk in certain circumstances, and in those circumstances, we would want them to have more protection.
Okay. Yes, middle on this side.
Opinions from the panel about the private right of action?
Sure, we can go down the line on private right of action, unless there's someone who doesn't want to talk about private right of action. But we'll start with Lauren.
I think it's more of a big political issue that is not one we get as engaged on. But I think when it's an important factor when considering the political tenability of an ability to move forward on a law, and I think it's certainly a challenging one to incorporate right now at the federal level.
I agree with her.
I'm going to paraphrase one of my colleagues, David Brody, from the Lawyers Committee, who often says marginalized communities have not been able to rely on institutions to protect their rights historically. And if we want to protect those communities, we need to provide them a private right of action. And I know Access Now and several other privacy-oriented groups who do have a position would definitely pull support of a federal law if it did not include a private right of action, and would never want to get to a conversation around preemption unless we saw a private right of action first.
A private cause of action is certainly one of the hottest issues with regards to public policy in privacy in the US and also around the world. What I can say is that I have not seen a law or regulation that lacked significant enforcement capabilities work anywhere. So the 1995 directive in the European Union lacked significant enforcement capabilities, and it has been written that massive non-compliance was the rule of the road in the European marketplace, including amongst many European organizations. The GDPR, notably, has brought in fines that can go up to as much as 4% of global turnover, and that got the attention of many, many, many organizations around the world. I think the FTC has shown itself to have some significant enforcement capabilities, but even in those indicative or sort of precedent common law of FTC enforcement type cases, they can't even cover the whole waterfront. California AG came out in support of a broader private cause of action under CCPA. Because I think there was a recognition from AG Becerra that his office didn't have the enforcement capabilities, the bench strength to really move forward. So I don't really have a point of view, and certainly the IAPP doesn't, as to whether a private cause of action is the right answer. What I can tell you is that for accountability to work, there has to be consequences in the marketplace for poor behavior. Whether those consequences are really effective enforcement by an empowered regulator or private causes of action in the courts, I think either could work. We just have to find the right mix.
Yes. Yeah. Yep.
I'd love to hear your thoughts on technologies that are potentially more ubiquitous and people can't opt out of, such as facial recognition softwares.
I'm on the World Economic Forum's Global Council on Consumption. And one of the things that we've been talking about over the last year is voice technology, which is not necessarily a new technology, but a new interface that people are using, and that different pieces of technology are building in. And I think that type of collection, as you walk past things, is going to be quite broad, including in cars, and what level people who are passengers in cars, including Ubers and Lyfts. Somebody brought up Ubers and Lyfts are consenting to that type of collection. So that's another one, is voice. Biometrics beyond face is going to be a big deal. It blows my mind, the technology that's being embedded into just infrastructure throughout communities and cities is going to lead to a huge just increase in passive collection of information.
So I'd love to respond specifically to facial recognition. And I think there are other technologies and innovations ahead of us that will similarly challenge our thinking about privacy. Something like facial recognition is going to fundamentally change the way we experience privacy in many contexts. And we don't currently have the tools, I don't think, from a public policy or an organizational risk management perspective to address some of those changes. I'm going to reference Woody Hartzog again. I'm a big fan of Woody Hartzog at Northeastern Law School. He's written about obscurity, and he is a very strong voice actually calling for a ban on facial recognition right now until we can get better controls in place. The idea of facial recognition where a picture taken in a public square can identify you even though you previously may have thought that you had the obscurity of the crowd as you were walking through that space. That changes the context of privacy as we experience those spaces. Those contextual disruptions, those changes to the context of privacy are really, really challenging. And this goes beyond a strict data-driven type of privacy analysis that we've had to date. I think facial recognition is one example of that. Just to wrap this point up, we're in the middle of strategic planning at the IAPP. We've just gone through 2 years where we've doubled in size and we are projecting continued growth. And as we look at issues like this, we actually see lots of growth in the years ahead for the IAPP because of the complexity and the challenge of these issues. We don't have easy solutions for them right now, and there is tons and tons of work to do for us to figure out the privacy structures that we need to put in place to manage those.
And I can just add another example from the car context, not just inside of cars, but increasingly autonomous vehicles. As they are understanding the spaces in which they're operating, there's essentially sort of a mapping war to be able to create high definition maps that are sufficiently detailed and accurate to be able to provide the baseline for autonomous vehicles' ability to navigate. And a lot of that will wind up involving externally facing video, as well as some LiDAR and other sensors that don't reveal as personal information. So in some of these testing areas, there are cars driving around constantly, daily, in the same neighborhoods, with video constantly going. And I personally have a lot of questions around, should we come up, that may be a space where we should come up with some privacy principles up front around retention, around whether they should have the ability to use facial recognition within these databases. I think right now they don't plan to. But there's also a use case for not, say, blurring faces or license plates, because some of the engineers argue that if you can't see where a pedestrian's eyes are pointed when they're crossing in a crosswalk, you can't tell whether they are looking up and seeing the vehicle and getting the signal to stop, or if they're looking down at their phone. And so that it can be important to keep faces in that kind of database, at least initially. So I think this technology is going to have to grapple with that, and how, questions around how you deal with some of these privacy protections where you're dealing with passersby or neighbors who did not sign up for the service and may not even be aware that their likeness is being included in a large data set that a private company has.
Okay, I think we have time for one more, and I see two more. All right, we can try to do two more with very quick answers. Yes, please, go ahead.
Thank you for your time. I wonder how the panelists anticipate we're going to be able to deal with the inferences that are being made about the data, because the data doesn't belong to the one individual person, but is part of the pattern recognition that empowers the larger sphere of knowledge that's being developed.
Sure, does anybody want to speak to inferences?
There have been really great conversations about societal, like the interest society has in privacy. I think that's going to be, is going to continue to be a part of the federal privacy legislation. And as to, you hinted at ownership again, so I'm going to point us back to Cam's really great blog post that went up today about ownership, because I'm really hoping we can stop talking about ownership of data. I think it leads itself to predatory practices.
Just a quick comment. I think there's a lot of social ambivalence. So the well-publicized case of a few months ago where a serial rapist who'd evaded detection and capture for 30 years had been caught because of this. His use of his relative had posted to genetic information to a social site. They were able to match the DNA evidence and focus on him as a suspect. Even those of us who fear a dystopian future were cheered that this guy got it, right? Like it was time, and maybe we have more faith in DNA evidence than we should. And maybe somebody will tell me that I'm wrong, but then there are other times when we hear other things where people's lives are jarred by hearing about an unknown sibling, or hearing that the person that he or she may have thought was a parent was not a parent, and it's Yeah, so I think there's a lot of ambivalence and we haven't sorted it out yet. I'm not sure, don't know if privacy law will be a vehicle to do that. We'll find out.
And we'll do the one more. Yes, thank you.
Thank you. Alan Rawl from Sidley Austin. If we were doing this panel in Europe, Brussels, certainly someone would have introduced the notion or concept of ethics. Ethics as a form of self-governance and therefore accountability that is brought about kind of internal to an organization. Do you all think that there is a necessary role for ethics as kind of digital governance within companies, organizations, especially as the data processing techniques are increasingly opaque and barely understood by the scientists involved, and certainly not by leadership who are not technologists. So do we need to evolve standards of ethics, which are then inculcated through kind of a culture of ethics and compliance as a means of establishing, self-accountability, if you will, which could be, I'm sure, somehow enforced externally as well. But what do you think about that notion?
So I'm a strong yes. I'm a strong yes on this. I think technological innovation moves too quickly for the law to adapt. I think the law is a trailing response to challenges associated with technological innovation, and ethical frameworks help us to manage that. One of the things that I say over and over again to our members when I speak around the world is that just because it's legal doesn't mean it's not stupid. And we see too much of that in the marketplace today, that there is behavior that feels creepy, that feels unethical, that doesn't feel right somehow, and yet it has the cloak of compliance around it. And so I think we do need to move to a better understanding of what are the frameworks, how do we apply them, how do we build professionals with the muscle memory and the muscle strength inside organizations to apply those frameworks in a way that's meaningful.
I think we should call it there to give the second panel enough of their time. So we're going to hear now about marketing and targeting, and I'll give it over to Stacey Gray. Thank you guys so much.
Thanks for watching. Be sure to like and subscribe for more videos from Brookings.